A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 11th webinar of Series 6 on Basics of Law titled Condominium Law. With this webinar, we are celebrating 40 BSL webinars for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the Chairman of the Webinars and Legal Symposiums Committee and the President of BSL, Mr. Rajiv Amarasuriya, and the Co-Chairman, Mr. Chaturaya Galhena, Secretary of BSL, and Mr. Pasindu Silva, Treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BSL for all the support and guidance. For today's webinar on condominium law, we have with us two esteemed panelists. Firstly, we have with us Mr. Saminda Jayasekara, attorney at law. Mr. Jayasekara obtained his LLB degree from University of Colombo in 1999, LLM degree from Cardiff Metropolitan University, United Kingdom in 2022, and is currently pursuing a diploma in nuclear law from University of Montpellier, France. Mr. Saminda Jayasekara is an attorney at law of the Supreme Court of Sri Lanka since 2001, a notary public, and a member of Chartered Institute of Logistics and Transport, UK, since 2017. Mr. Jayasekara commenced his law practice as a junior counsel to the late Mr. Hemakati Alvis, attorney at law, who was the founding chairman of Fairway Holdings. He then became the first employee of Fairway Holdings in 2004 and worked there until 2018. He was the group director, legal and regulatory affairs at the Fairway Group. In 2019, Mr. Jayasekara commenced the work as an independent private law practitioner, specializing in property, condominium, and regulatory approval areas, and presently a consultant to many organizations and condominium development projects, such as Lanka Property Web, Marina Square, Altea, Iconic, Baileys, and Fairway Holdings. Mr. Jayasekara has experience in public sector as a member of the Condominium Law Review Committee, appointed by the Ministry of Justice, convener of Atomic Energy Nuclear Law Review Committee appointed by the Ministry of Justice, chairman of Property Development PLC, chairman of Sri Lanka Atomic Energy Regulatory Council, independent director of Sri Lanka Bureau of Foreign Employment, and executive director of Mahapala Trust Fund. Mr. Jayasekara also became a panelist at Annual International Nuclear Law Institute organized by International Atomic Energy Agency, which was held in October 2024 in Vienna, Austria. I warmly welcome Mr. Saminda Jayasekara, attorney at law, for today's session. We also have with us Mr. Senaka Diseram, attorney at law. Mr. Diseram graduated with a Bachelor's of Law degree from the University of Colombo. Mr. Diseram enrolled as an attorney at law in the year 2002 and has been practicing in the areas of civil and commercial law for the period of well over 23 years. Mr. Diseram obtained his master's in law also from University of Colombo. Mr. Diseram is also an associate member of the Chartered Institute of Management Accountant, UK. He is also further qualified as an arbitrator from the Chartered Institute of Arbitrators, UK. Mr. Diseram is a life member of Bar Association of Sri Lanka since 2002 and presently a member of its Financial Committee. Mr. Diseram was appointed as the chairman of the Junior National Law Conference in the year 2004, which is now one of the key events of Bar Association of Sri Lanka. Mr. Senaka Diseram was appointed as the convener of the National Law Conference in the year 2022. Mr. Diseram has been appointed by the Ministry of Justice as the convener for the Committee on Law Reform on Apartment Ownership Law. He is also presently involved with the Condominium Management Authority to bring about changes to the existing regulations in relation to condominiums. Mr. Diseram is also a final year lecturer and examiner at Sri Lanka Law College. I warmly welcome Mr. Senaka Diseram, attorney at law, for today's session. Without taking much time, I would like to hand over the session to our panelists. Over to you, sirs.
Shaminda, you can start.
I think, Mr. Diseram, you start with.
Yes, I'd like to welcome all of you for this webinar. And on behalf of the two of us, I'd like to thank the Bar Association for inviting us. This is a very timely topic, and there is a lot of scope for lawyers. And it's a thing that is being spoken about, but not many people are well educated in the law in relation to condominium law. So without wasting much time, I promised the president and the secretary and the chairman of the committees this thing, that the two of us will just do with you all a little bit of basic law and we will be doing it. We'll share our thoughts on certain sections, and I will now share our slides with regard to what we are going to teach you all today. So basically, if you can see, can you see, Shaminda, is the slide up?
Yes, yes. It's
All
fine.
right. So basically, when you go and study condominium law, the reason for the development of condominium law is on your slide now. Basically, everybody wants to move to cities. Livable land is scarce. So the only way we can do these things is by going upwards. Since we can't go downwards, we are going upwards. And the whole situation, not only in our country, in cities, is because there is lack of land. So if you see the next slide, both of us selected this slide because, you know, this is one of the largest residential buildings you get in China, in the Zhangzhou province, where over 20,000 people live in this apartment complex. In this apartment complex, you get shops, you get little hospitals, apartments, residential units, pools, small little areas where you can attend it to your recreation. All this is in one building, but it's not possible if you don't have the proper regulations and laws enforced to have something going like this. So if you go to the internet and look at this building, there are many YouTube videos on it because it's like a world record. You can have a look if you like. And we will go to the regulatory framework, why the condominium law had to be created. So all of us know in Sri Lanka, we have the Roman Dutch law, and the Roman Dutch law has this uniform theme that goes across in land law, which is called superficies solo credit. So the three Latin terms that I have put on the screen, they are in almost all the case law you find. If you look at case law, you will see these three themes, and what is mainly said is all that is built on the soil belongs to the soil that it is on. Things that are attached to the earth go with the immovable property. He who possesses the land possesses all that is above it. So these three concepts are part of our land law. And it was, if you don't have statute law, this is the law that will be applicable to us also in Sri Lanka with regard to properties. So because of this, we had a situation, this is which is recognized from 1895. If you look at De Silva versus Haramanis 3NLR case, so those of you who are non-lawyers, and if you all are looking at this, you can see from 1895, this concept has been recognized in Sri Lanka. This is a decision that was given by the Privy Council, and as you know, Sri Lanka was a colony, and all the final decisions were taken by Privy Council. And this decision on the 7th of May, 1895, it says parties seem to agree that by the law of Ceylon, the builder of the land on a house on other man's land at once acquires saleable right to that house. However, it is not the law. The house becomes the property of the owner of the soil on which it is built. Between the owners and the builders, there may exist equities such as the right to compensation, but the ownership of the building cannot be in the other. So basically what this is saying is, if I have a 10 perch land, we'll say it's worthless, but I have a 10 perch land, and Mr. Jayasekara, who is also going to teach you all today, builds a huge condominium property worth millions on that property. Mr. Jayasekara will not own that building. Basically, I will own that building, and Mr. Jayasekara will have equitable rights on that building against me, but he will not own the property per se, given the law that we had in the country. So this became a huge problem, not only in Sri Lanka, but in all jurisdictions. where there was an issue when you go upwards. So if you put up a building, there was a requirement to do something where you have created a situation where you can divide the building into little areas and give sole ownership to different people. And the only way we could have done that, and the only way even it was done in other jurisdictions, was by statute law. So those of you who know what statute law is know that it supersedes all other laws. And there was a whole heap of legislation that was brought in Sri Lanka to do this. And one is the apartment ownership law. And you can see the others: the Condominium Management Authority law, the Land Restriction and Alienation Act, the Registration of Titles Act, the municipal laws, and now we have the latest Colombo Port City Economic Commission Act, and we have a liquor gazette that has been published in 2017 by the Condominium Management Authority. So these laws came into being, and we managed to create a legal platform where we can have condominiums in Sri Lanka which can be individually owned and away from the land that has been built on. So without these laws, you can't have a condominium. Basically, what I told you previously, the slide that I shared you, all these concepts will apply, and you cannot own a condominium separately. So both of us today will be talking to you on the first one, because we don't have time to discuss everything. We will be dealing with the apartment ownership law. The other ones are, if we go to deal with it, we'll have, Mr. Jayasekar and I will have to stay here till nightfall. So we are dealing with the first one, and we will go ahead with that. So if you look at the apartment ownership law, it was created as far back as 1970. We had numerous amendments, which I have put on on the slide. One of the most key essential amendments that came was the Act number 39 of 2003, which allowed a thing called a provisional condominium, And with that, people managed to start doing pre-sales. Now, when we go on in this discussion, you will know what a provisional condominium is. And the Act goes on to describe what these condominiums are. So this is not something new. We have had it from 1970. It has had a steady growth. We had discussions a few years back where the Minister of Justice appointed a committee. Mr. Jayasekar and I were on that committee, and we made some proposals for change. So let's hope these changes come into being, and we'll have another amendment hopefully to this law so that it is in line and in keeping with the new developments of the law. So as I told you, when it comes to legal concepts, condominium law is based on basically four broad legal concepts. One is individual ownership of property, co-ownership of property, law relating to societies and companies, and law relating to servitudes. So all these four has been combined together and put into an act. So if you really want to do further studies on this, like for example, when we do further studies, like if you go to a university and all, these are the basic four concepts that you will study further on in this law to know how it has been put together and formulated by way of an act. So we are going to discuss these 5 things today with you. That is condominium property, common elements, accessory parcels, share value, and servitudes. Not too much servitudes, but the up to share value we'll be attempting to finish with you in a basic format. So with that introduction, I will leave it to Mr. Jayasekar to start on section 2 of that, which deals with how a condominium project starts and the land on which you can start this project.
Thank you, Mr. Desaram. Basically, this is how describe the condominium building that out of among other buildings. Basically, it's erected on an alien land as a one land parcel. It should be one building in one land. That's whatever the completed building. It should be a condominium property, or maybe proposed to be erected, say in a land and the say that should be a proposed one that you called provisional condominium plan. It means that in a future date that you have all approvals, but not yet commence the construction. That is called provisional condominium property. And then in a stage where that the partially completed the property, in that one you call the semi condominium property.
Yeah.
Shall we go to then if you think about condominium property, this is a basically only recognized completed condominium one. Once you completed the condominium, and if you registered this property as per the apartment ownership law in the relevant land registry, only it become a condominium property. We'll say if we have not registered this property while we are constructing and we are going on the sales agreement, even that stage we not consider this property as a condominium property. See, and the semi-condominium properties, while we are constructing, maybe we have 2 or 3 buildings, then those 2 or 3 out of that, if we completed one building, then we can go for partial COC, and you can have register that as a semi-condominium property. That the provisional condominium property, as we proposed earlier, it is just got approvals, but if you can prepare a condominium plan, that the same provisional condominium plan, and then can do a provisional condominium declaration, and then you can register that one also. That is called as a provisional condominium property. And this provisional condominium property, that is that newest one introduced to Sri Lankan market in as per the latest amendment in 2003. In that, the main reason was that you all know, mainly we are going for pre-sales in the market. For going for pre-sales, but the issue is most of the developers, they will just get the plan, and out of the plan you are selling. For to that answer that created, then when you are having a building plan, approved building plan, through a surveyor, you do a dotted line plan which will be built in the future, and based on that one, that you prepare the provisional condominium declaration, and you get it registered. That is called provisional condominium property. The semi condominium property is bit different. In the semi condominium property, either maybe you have 2, 3, 4 buildings in one condominium complex. Then one building you are completing, and then getting the certificate of conformity, and then you do the condominium plan for that area and register. Or sometimes in a one building, part of the building completed, that and part of the building will be livable condition. For that area you get the partial COC, and then prepare a condominium plan and the condominium declaration and register, then it's a semi condominium property. The condominium property basically that the whatever will say there are house 1,000 units, or there may be 2 or 3 towers, entire complex completed. Then at stage, then you complete this thing and subdivide, and prepare in the condominium plan and the deed at the register in the land registry. Yeah, then in the Apartment Ownership Law Act, originally it was Section 5. We are talking only about the condominium, but that these 2 new provisions came in, as we mentioned in 2003 amendment. In the provisional condominium plan, it mentioned in Section 5A, then the semi-condominium plan, Section 5B, and the main condominium plan, it's still at the Section 5. Then basic that according to that sections, we have to make these plans and then only submit to the land registries for approval. As per the Section 3A, 3B, and 3C, that we have to, that the process is as that now that we already discussed how it goes. We are mainly we will get the development approval. In later stage that we will go through the all approvals. Here basically that once you get the approval from the relevant local authority or the UDA, mainly UDA for these bigger size apartments, then that you are capable of selling these units to the people, as well as you are capable of commence the construction. During that period, that if you are thinking of going for a provisional condominium plan, as we mentioned, we get a license surveyor, draw the condominium plan, and submit the condominium plan, that this provisional condominium plan to the condominium management authority, and you will get the certificate to develop this property as a condominium property. Then thereafter you have to go to the land registry and you have to register the same. In the same process we have to go all three, but there are some different requirement when you are submitting this provisional condominium, semi condominium plan, and the final condominium plan. Mr. Desarum, shall we go to the next one? Yeah, that the main purpose for provisional condominium plan approval and the registration was to protect the clients, that whoever buying these properties, that especially if you are going for provisional condominium and registration, that there are a few things asked by the authorities. Number one is that the availability of the funds, that how you going to fund. Do you have money, that do you have equity, then you have to provide the financial proof from a registered license bank or financial institute. If not, if you having some bank facility, you have to show those things. And also you have to give a construction plan, and how do you meet those construction plan, what are the plans, then what is the budget, those things you have to submit along with the provisional condominium plan application to the condominium management authority. So when you then thereafter even say that final condominium plan, you are not liable to ask those things, because that final condominium plan, it's already done. But the biggest issue we had this clause is, although all these requirements are there, but it was not compulsory. Because of this thing, that most of the developers are not following this provisional condominium plan process, that in the Mr. Desarum and that myself, that we were in the same committee for enact this act, we proposed that this provision for the provisional condominium plan to be compulsory, but we'll expecting in the next time also it will be okay to compulsory provision. Shall we go to the next slide? Semi-condominium plan is a bit different from the provisional condominium, because that in the semi-condominium plan we have two sections: completed area and incompleted area. For the completed area, that we have to get COC from the relevant local authority. It means that in that section it should be 100% livable condition. It means that you have to have the water and electricity connection to your premises. You have to have the completed and approved fire safety system, elevators, generators, everything should be properly managed and maintained for that area. That you have to show and prove those things, and you have to get the COC for that section. And also in the semi-condominium property, there's a section which not completed. For that section, like provisional condominium, you have to show how do you find money to get it completed, the other section, and is there any financial institutes, that how do you go and how do you finalize the everything. Also, that if you have mortgages, that you have to mention those mortgages, what are the things. Top of that, you have to get a clearance letter from that bank or financial institute, stating that there is no objection to register this property as a semi-condominium property. And the condominium plan is the widely known fact among us, Condominium plan is basically that once you completed the building, you have to get the certificate of conformity to the entire building. Thereafter, you have to go to the condominium management authority and get the certificate for common amenities. Then in that they will check all your drawings, all your certificates, all requirements, especially the common amenities and facilities. After evaluating everything, they will issue their certificate, and with their certificate we have to prepare the condominium declaration and submit for registration at the land registry. Together with condominium plan and deed, that you will get the final approval, and thereafter only you can issue deeds to the clients. Basically there's a timeline given for completion of the condominium, but although the timeline is there, that it will never it's very rarely that any developer is following this thing, and it's actually it's not, sometimes it's not practical. It says that within 8 months from the date of the first agreement to sell, that you have to complete this building. Mr. Diseram, I think that next part you can handle.
Yeah. So basically, what Mr. Jayasekara was discussing is how this whole process is going to take place. We have, when it comes to condominiums, you have a property. Basically, you cannot have a condominium project in two different properties. So if I recap of what Mr. Jayasekara was saying in section 2, it talks of one land parcel. So this is also something that we were discussing at the committee stage, whether we can change this, where you can have a condominium project in two different land parcels. So basically it's one land parcel that you have the condominium. And as he said, there are three concepts: provisional condominium, semi-condominium, and condominium. And how the process of registering the requirements of these plans and how you register it. And he discussed what the timelines for these things. So basically, after that, what he was emphasizing is that it is not mandatory. Now, that is the whole problem we have in Sri Lanka. The provisional condominium plan, though, is good. It's not mandatory. And this was discussed in this case of Malika Fernando versus Nagesh Fernando, where Justice Jayavikrama, in deciding this matter, said that it is not compulsory. So you can have an apartment or a condominium where it is not mandatory to register a condominium plan. But if you are going to do sales with regard to units, then definitely you need to have a registered condominium plan. So the effects of condominium plan registration is twofold. And one is you have to identify the difference. Now, a condominium and a semi-condominium is different to a provisional condominium. Now, as Mr. Jayasekara said, a condominium is already built. You can see it, you can live in it, you can sell it, so on and so forth. A semi-condominium is also a project which is halfly done, where you have minimum of 2 units which is livable, where you can live in it and all that while the project is going on. Now, I want you all to distinguish a condominium, a semi-condominium, as against a provisional condominium plan from here onwards, because a provisional condominium plan is where there is a plan, but there is no building. So there is a difference. So now what happens, like when Mr. Jayasekara said that when you register this, what happens? So once you register a plan, there is a difference between a provisional condominium plan registration and a condominium plan and semi-condominium plan registration. Now, that is what I'm explaining in this slide. That is, once you register that plan, it creates the condominium units. So if you register a condominium plan and a semi-condominium plan, it creates condominium units. It creates a management corporation. And automatically, there are a set of rules in the second schedule of the Act, which says you can't do this, you can't do that, you can't have pets which are a nuisance, so on and so forth. You can't bring substances which are dangerous. That set of rules will be applicable to this property immediately upon registration. So the effect of registration is there in section 7, section 9, where it says moment you register, then what happens is that building breaks into separate legal units which are saleable as against that concept that I told you about superficies solo credit. So moment you register the condominium plan, moment you register the semi-condominium plan, the units become separate legal entities. And for that, we have created this small diagram for you. And if you see, now this hypothetical drawing in, I have put the building on, and Mr. Jayasekara was also kind enough to share his thoughts with regard to what we were saying on the registration of a condominium plan. Then, if you have not registered a condominium plan for this building, the person who owns the black area, the property, will own 1 to 4 floors. But that if you have registered a condominium plan or a semi-condominium plan, then you can break this building into units 1 to 4, and thereafter you can do sales separately without the obstacles we had in our Roman Dutch law. That is why the statute law came in for the purpose of doing this. So this has been explained not by Mr. Jayasekara and Mr. Diseram. It has been explained by Justice Veera Surya in Vikramasinghe versus D'Souza, where he goes on to say that moment you register a condominium plan, the units get broken up and the condominium plan gives effect to individual ownership of the different apartments that are there in the building. So, as I told you, this does not happen when a provisional condominium plan is registered. The provisional condominium plan is only applicable subject to these requirements that you see on the slide, subject to these requirements that are there on the slide. Whereas if it's a condominium or a semi-condominium plan that is registered, it's only not only this, you have the things that I told you previously, which happen, that is A, B, and C. So coming back to what I was telling you, when does a condominium plan, a provisional condominium plan, a semi-condominium plan get registered? Now, this is very important because if you are a notary or if you are in a condominium building, you must know the exact date when this condominium plan or provisional condominium plan comes into force. And this is important for 2-3 reasons. One is, if you are a notary, if somebody comes and tells you, can you come do a deed for me for the unit I am staying, you must check whether the condominium plan is registered. And the management corporation also comes into being, which is also after the condominium plan is registered. Now, I think Mr. Jayasekara, we once discussed where somebody had registered some deeds prior to the condominium plan. Can you give some example of what we were discussing some time back, where prior to the condominium plan being registered, people had executed some deeds? Can you remember?
Yeah, that what happened was that basically now once you register the provisional condominium plan at the land registry, that land registry will open separate folios for each and every unit. But in the section 9 of the apartment ownership law very clearly mentioned that in the provisional condominium plan, effect is only you can mortgage those units, and only the developer can enter into sale agreements with prospective buyers to sell those units. There are no provisions to sell this thing. But however, maybe the lack of knowledge of the registrar as well as notaries, that some developer wrote deeds, executed deeds, and the notaries also notarized those deeds and submitted for registration, and few that there was a 1 or 2 complexes in Nuhrili area that the all from the provisional condominium plan that all deeds registered, but there was no building, and that was totally against the law.
Yeah, so those issues are still pending, I think, and there is one also in Gampaha. So these
very recent
lack of
come
law.
across in the one property in Colombo also.
Yes, and people are grappling with it. So as you So the important thing is know the three concepts. Provisional condominium plan, you can't register deeds because of the fact that we have told you today. The provisional condominium units are not legally recognized units by law. So the next item on the list that I told you that we will discuss today is common elements. So if I just backtrack to what we have discussed so far, in the four little concepts that I said, we have discussed now with you in basic condominium property. Condominium property is threefold: provisional, semi, and final condominium. Now we are going to discuss common elements and accessory parcels and what is share value. So if you basically, a common element is what is common in the building. If you look at a building, you will find car parks, lifts, stairways, and various things, the recreational areas, you get the gym. All those are called common elements. But to identify what a common element, in different countries, it's done in a different way. For example, some countries, they recognize the private units or apartments separately, and they say everything else is a common element. In the other regime, they say, okay, these are the common elements in a building. You have to set it out. So we are, as in Sri Lanka, we adopt the second method. The Act says what common elements are. There is a gazette which says how you describe how common elements are. So basically the columns, the common walls, the what you call the lift areas, all these are common elements. But it's not an easy task to identify a common element. And you have to go through the condominium plan to know what a common element is. Now, the common element is common to all, and it is owned by all. It is owned by all and managed by the management corporation. So, as I told you, the concepts of law, it is like co-ownership. It's owned by all the unit holders, managed by the management corporation, which we will come to, and it is not an easy thing to identify in some buildings. Mr. Jasekar, would you like to add something on common element?
Basically, that the common that now that as per the latest regulations of CMA, that top of the building, that in the rooftop, that you can't, you have to be common element, that the individually that nobody can't own part of the that top of the building as well as the ground also. Those are the main thing. And the other thing is that the always that when you are entering from your house, that the apartment unit, you are entering to a common element, and from the gate to the your unit, that there should be independent pathway everyone to through a common element, that you can't have access through somebody else's premises.
Yeah, so basically those legal rules exist for what you call common elements. The next one we are going to deal with is what an accessory parcel is. Now, we are all commonly known as accessory parcel is basically a small portion of land in the building which is attached to one or more units. It can be attached to one or more units. We know this accessory parcel very well through car parks. So if you see, some of the developers they don't have common parking, they will assign you a car park. So how do they do that is through accessory parcels. So in the condominium plan, they will have a portion which is attached to one condominium unit. So that is what you call an accessory parcel. So in advanced buildings, for example, if you go to certain buildings, there can be maybe on certain floors, there is a exclusive area for that floor only. For example, we can see there are penthouses in some buildings on the topmost floors with dedicated loungers. That is, those loungers are only for the penthouse owners only. So those are areas which are called accessory parcels. So that entire area of the building is an accessory parcel which is assigned to those penthouses. But that is not very common in Sri Lanka. we are associated with the accessory parcel because of the car park. And if the car park is exclusively to be governed and owned by the particular person of that particular unit, then it has to become a accessory parcel. Mr. Jasekar, you like to add anything on that?
Yeah, say in before coming to this 2017 Gazette, that the developers gave car park on exclusive usage basis from the common elements. But after 2017, it was clearly mentioned then, either you have to give car parks by way of accessory parcel, or just first come first serve basis, that the say you in a common element you can't give exclusive usage of car parks. And top of that, there are sometimes that in some that store areas, those things also can give as accessory parcels. But the main thing is that the accessory parcels cannot deal independently, because say that if there is an accessory parcel, always that accessory parcel should be attached to one or two or some apartments, that the you can't sell like that. The if I have a unit in a condominium and I have two accessory parcels, accessory car parks, I can't sell one car park. If I am selling, I have to sell entire apartment and two accessory parcels. That independently you can deal, or you can't exchange accessory parcels. You can't do those things.
Yeah, and I think another mistake that our colleagues make, and I think it's good for younger lawyers to know, is when you do a deed, some of our notaries don't include even the common element in the deed. I think, Mr. Jasekar, you can explain further because you are more experienced in notarial work. And some people miss out on the accessory parcel. Moment you miss out on the accessory parcel, it is gone for good, because some of these owners, they sell and go abroad. Can you explain a bit on that also, Mr. Jasekar, since you have more experience in the notarial world?
Yeah, but yeah, in a normal deed, that if you get you get only two areas, but the first one is that you get the land area, that where that is there in building also, and the second schedule maybe say that if you have a right of way, that's all in a normal deed. But in a deed that related to a condominium property, you get few areas. That first one is in the first deed, that if you are getting from the developer, you will get the main land where that you build this condominium property. Then the second schedule, that you will get your relevant unit, that where it belongs. Then in the same schedule, you will get the accessory parcel. You have to mention, very clearly mention, what is the accessory parcel and the boundaries of the accessory parcel also, because that accessory parcel also part and parcel of this unit, and it also belongs to your client. And in the same schedule, you are mentioning that you own this percentage of the common areas. Common amenities and the common elements. In the next schedule, we are giving the list of common amenities, but maybe sometimes it's coming to 40-50 pages, but you have to clearly mention, because that only your client knows and the future clients knows that these are the common elements we own sharedly. Those things we have to mention. You can't miss it, those things. And top of that, is there any that by road or right of way, that those things also have to mention in the deed.
Yeah. So we'll move to the next area, share parcels. Now, as Mr. Jasekar said, there is a proportion of what is a ownership. Now, we told you a few minutes ago, there is a thing called a common element. So as I told you in that, when describing common element, it is co-owned. It's co-owned by people. And how then one must know in what percentages you will co-own the common elements. So if Mr. Jasekar and me are co-owning a property, then we must know whether it's half and half or 20% or 80%. So in condominium properties, this is calculated by the term share parcel. So if you look at Sri Lanka, there is a term called share parcel in the law, and the share parcel is generally a percentage. It is stated in the condominium plan, and that will give the percentage of ownership to each owner with regard to the common element. So basically, the share parcel is calculated in numerous ways. In other countries, There are complicated calculations how to identify a share parcel. But fortunately for us, we go by a simple square foot method. There are two general methods, by valuation method or square foot method, but we go in Sri Lanka to the square foot method. And as lawyers, as notaries or whoever, we don't need to do that calculation. That is there in the condominium plan. And the importance of the share parcel is stated now in the slide that I have put to you, that the contribution of maintenance, for example, unlike a normal house, in a building, you have to do maintenance. There are two funds that are created and you have to contribute money to that fund. And how you contribute to that is based on the share parcel. Then you have an AGM at the management corporation, which we will come to. And the weight of the vote of your at the AGM depends on the share parcel. Also, if the condominium property is destroyed, then you're back to the base property, which I showed you earlier, that black area in the little diagram that I showed you. Then how do you divide it? How do you divide the property? If the building is destroyed and it's no more, then it's the percentage of co-ownership is determined based on the share value. So that is with regard to the other concept of share parcel. And also this contribution of share parcel is there in the condominium plan in a proportion of how it is calculated. Mr. Jayasekar, would you like to touch on the share parcel a little bit? The percentage?
Percentage that the same that irrespective of the, maybe you sometimes you own 1 or 2 units in a condominium, but maybe the penthouse is bigger, then the percentage of the it calculating only that you consider only apartment areas. We'll say 100 units in the complex of the same size. Then you divided by say that 100 unit that whatever the area from the main that the total not from the total buildable area, only the house unit areas, that then you get your number. And other thing is this share.
Okay, so from that we end the other topics with regard to share parcel, and we come to the next one, which I told you is the management corporation. So what is a management corporation? Once you register a condominium plan, automatically this legal entity known as the management corporation is created. And management corporation, unlike a company, you don't need to go somewhere and get a certificate of registration. Moment you register the plan, this legal body comes into being. And the condominium management authority, once the plan is registered, has a process of registration there, but that has nothing to do like a registration like a company. They will give you a document saying that the management corporation is incorporated, and you can use that to open bank accounts and so on and so forth. So it's a legal entity, and like in a company, it has members. So the members are all the owners of the building. So all the owners of the building are the members, and it is functioning like a society has a constitution, like the company has articles of association. This also has some rules of how you occupy and run the building, and that is done through the first schedule of the act. So you can amend the first schedule to change certain things of the rules of the management corporation, but the basic structure of the first schedule can't be changed. Basic structure can't be changed. You have to run the management corporation under those rules. And the main purpose of a common management corporation is to manage the common elements. And as I told you earlier, common elements, though, are managed by the management corporation. The management corporation does not own the common element. But you have to understand that in large buildings, sometimes there are leases that are done with regard to common elements. For example, if you see in big complexes, there are Cargill's Food City, there might be a laundry, there might be a restaurant, and we have to give some legal title to those guys to occupy these premises. So that is done by way of a lease, and that lease is signed by a management corporation. Mr. Jayasekar, I think you can explain your experience on that.
Yeah, it worked in two ways. Sometimes the developers are keeping those areas as commercial parcels. Then, if it's a commercial parcel, if it should be a mixed development project in a commercial parcel that directly rent out by the developer, then the income also going to the developer, and as per the share value of the parcel that the developer has to pay to the management corporation. That is one way. Or otherwise, sometimes that these areas in a common element. If it's the common element, then the management corporation the management corporation can't sell it, but the management corporation can rent it out and get some money. That in the both ways are working on but we'll say in the bigger complexes like say Colombo, CCC building, Shangri-La, in all those areas, these shopping complexes are running independently as part of the commercial parcels owned by the developer, not owned by the management corporation. But in some areas that the management corporations are running those places.
Yes. So there are funds that need to be obtained. Now, for example, a building has to be maintained. So you get the management fund and the sinking fund. So the management fund is basically contributed as per the share value that I explained to you a little while ago. And there's a thing called a sinking fund. So you apportion some of the money of which you collect into a sinking fund. And the difference is the management fund you can use for day-to-day running, and you can use the funds for maintaining the building through a resolution that you will pass under the council, and the bank will follow that. The difference with regard to the management fund and the sinking fund is the sinking fund has more restrictions to remove the money, and it can only be used for the development or maintenance of a major repair of the building, and it needs a special resolution. And there is a conflict between the English Act and the Single Act, how you can this thing. There is an interpretation to say that you have to go to the CMA to get approval to use money that is there in the sinking fund. But I see most management corporations using the sinking fund money sometimes without the approval of the CMA. So those are the two funds of a management corporation. We have home rules. If you all are selling an apartment, buying an apartment, or if you're in a complex, it's not like your general house where you can live the way you want. Schedule 2 of the Act specifically sets out rules where you can't do things, you can't bring hazardous material, you can't be a nuisance, you can't have a pet who is a nuisance, so on and so forth. So Schedule 2 of the rules of the Act automatically come into force. The Gazette also, which I told you, there is one Gazette in this industry, and that also has rules with regard to how the owners should behave. And if you want to enforce those rules, the council of the management corporation can enforce it, or even any one of the owners can go to court and enforce the rules. You can't amend the basic rules, but you can add on. For example, you can improve on the rules, but you can't delete the rules of the management corporation. Now, we have a thing called the Condominium Management Authority, which is a nationalistic association. It's generally under the Ministry of Housing. And the main thing is not only does it deal with national issues in regard to apartments, it also deals with inquiries. So if you want to complain, you can go here. This is generally done through the government arm. So another important aspect is the Land Restriction and Alienation Act. Earlier, the government restricted sale to property to foreigners. Then it was totally removed, and now you can buy, a foreigner can buy an apartment, but there is a method in which foreign direct remittances have to be brought into Sri Lanka when buying an apartment by a foreigner. Mr. Jayasekar, you can explain how the transfer is done for a foreigner.
Basically, that for foreigner, that earlier it was up to from the fourth floor onwards only that foreigners can buy. That restriction is no more. Now any condominium unit that foreigners can buy, but there are restriction, that the restriction that mainly that entire money you have to take from foreign exchange, and it should come to the country via special account. It's the account called IIA, Inward Investment Account, that the foreigner must send that money to that account, and from that account to then get it transferred to the developer's account. Say that although we'll say that if you are a foreigner and if you are working in Sri Lanka and if you earn rupee income in Sri Lanka, although in that instant you that foreigner can't buy that, especially foreigner, that's the main rule, that the all entire money, all exchange come as the foreign exchange from out of the country, that he can't earn Sri Lanka and buy the property, or that he can't get a loan from Sri Lankan bank and buy the property. Those are the restrictions.
Yes, can you remember, Mr. Jayasekar, we were discussing as a notary, when you are buying a property from a foreigner, what do you need to look at? Can you remember we discussed when you are buying a property from a foreigner?
Yeah, when we buy in a property, we'll say that if you that the client came to you in a condominium, that you are buying a property that the presently owned by a foreigner, then even in that instant you have to check when the foreigner bought this condominium property, whether that he followed the same procedure. Otherwise, that because if he don't have the proper title, then when it passed to us, we also don't have the proper title. Because of that thing, we have to check it. That when my client is a foreigner, that we have to advise them that please follow this path. And again, that when we are buying a property from a foreigner, that we have to check those things also, whether that money came to Sri Lanka, then we have to, sometimes we have to get the bank statement also to verify that fact.
Yes, so that is very important. If you are representing a foreigner to buy, or if you are buying on behalf of one of your clients from a foreigner who is the seller, then you have to be very careful, like Mr. Jayasekara said. That is the importance of this act. There is no restriction at all for a foreigner to buy on any floor. I think both of us still get calls. It's that fourth floor rule still there. No, it's not there. But the inward foreign direct remittance is the issue. You have to check that. As long as that is there, there is no issue. Then we have the Port City Commission, which came about in 2021. The commission is entitled to make outright sales of condominiums without having the issue of leasing government property. You register companies with the Port City Commission. It can lease and transfer on freehold basis. It can make regulations. It has already made a few regulations. And if they pass the regulations, then that supersedes any other regulation that is there in the country with regard to condominiums in that particular area, which is the Port City area. So this commission also has authority to have a division on the Condominium Management Authority, where it can deal with issues in that area. I think when the buildings come up, we'll see this area being more active and more activity happening with regard to regulation and disputes. But at the moment, there is nothing much happening there with regard to condominiums. Only the investors have come in, companies have been registered, they have opened a few bank accounts, things like that. I think, Mr. Jayasekar, you can deal with the main documents in the condominium project since you have experience in that.
Yes, that as a notary and a lawyer, that we have to, that we are getting the first, that initial deeds, that when we are building a property, that like a normal property, that you have to do a title search, and you will get the local authority documents, initial deeds and plans. Then you have to go through those documents first. Thereafter, that the stage will come to the building plans and the council drawings. Before that, you have to go some approval process, we will discuss later. In the building, that before the say that the preliminary planning clearance you will get, then thereafter that you will get the building plan as well as the development permit. Development permit is the document that where they put all conditions. Then you have to follow these rules, that environment regulations, water, electricity, whatever the everything that it covers in the building plan along with the development permit. Thereafter, there are many kind of drawings related to condominium. It's a big building that electrical, plumbing, water, telecommunication, gas, fire, everything, and you have to keep these documents that the first we are making drawings through our engineers. Thereafter, that we have to have a similar kind of the inbuilt as built drawings also. All those drawings we have to provide to condominium management authority when we are getting our certificates. Then the stage of this provisional condominium plan, as we discussed earlier, that the very few developers obtain the provisional condominium plan and the deed. That no, it's a normal practice is not having this thing, and very rarely that we will get that provision. And thereafter, this certificate of conformity stage says, certificate of conformity means that you all know, it means that this building is in a livable condition. That, as we discussed, there are two kind of certificate of conformity we are talking. One is the partial certificate of conformity, where then thereafter you can do a semi-condominium plan and the semi-condominium declaration, or completed fully COC. That means that the entire building is completed. Then the CMA certification also, in all these three stages we will get it. If you are doing provisional condominium plan, we will get provisional CMA certificate. If it's a semi, then we will get the certificate, and the final one also we will get the certificate. Thereafter, we have to prepare condominium declaration deed and submit for registration. Then those are the stages when we are building and completing the condominium. Then thereafter, that once you register your condominium deed only, that you can do your deed for your clients. Okay, that's the next step. We are going ahead with the documents, that when whatever the stage you involved in this project with your client, maybe at the initial stage, in that moment you don't have any provisional condominium plan, no any condominium plan, then you have to check the original deeds and plan. But the thing is that if you in a latter stage or the final stage, at that time you have to check not only the initial deeds and plan, whether they have obtained the COC, whether they have go to the CMA and obtain the CMA certificate, then they have done the condominium plan, condominium deed, is it registered in the land registry? Those documents also we have to check it.
Yeah, now if you look at this list in front of you, that is what Mr. Jayasekara was explaining. Just for me to add one more thing is certificate of conformity is required for you to occupy the building. Now, this is blatantly violated by most of the developers. Without the certificate of conformity, in law, nobody can live in a premises. I think some of the houses also that are in Sri Lanka don't have the certificate of conformity. So sometimes it is essential to have the certificate of conformity before letting in people to live in that. Otherwise, you're violating the law. I think the next slide also, Mr. Jayasekara will deal with.
Yeah, to add something to Mr. Desaram's one, that as per the 2017 regulations, CMA very clearly mentioned that without COC you can't occupy the premises. But say that many of the developers, some are that the very big companies, they also based on the architect certificate, which is that we call certificate for practical completion. Based on that, they are giving the occupation. So that recently that I got a notice that and I asked from the developer, how do you give? Then the developer said, okay, we will get a consent letter from the owners stating that we know that we don't have the COC, but we are going for occupation. It's like that we are having some agreement with somebody which is illegal. That basically, that as per the basic law, Mr. Desaram, that you can't do that.
Yes.
Right. And then say that the next one is that what type of documents that we are involved in a condominium project. As that earlier we mentioned that before the condominium property, it's a normal property, then we have to go through all the normal title works, that the transfer, that whatever the documents you have, that we are talking about the lease agreements mainly. the government properties which UDA is giving for these kind of developments, UDA giving only the lease agreement to developer. Thereafter, UDA giving the deeds only for the residential units of that building. For that, we have to go through the entire process that the lease agreements given by the UDO or any other government, or if it's a private property, that directly either deed of transfer, deed of gift, what you get. Then we have to check any mortgages are there that at the beginning of the project as well as the middle of the project and the end of the project also. Sometimes that they will complete the building, they will give you the set of the title documents, and when you checking your unit, the unit is not mortgage. It looks like the unit is free of encumbrances, but as per the apartment ownership law, that is there is a mortgage in the mainland that that mortgage come into these units also. That you have to very very clearly do the search, not only on your unit, but before condominium register, that the mainland mortgages also, whether it's cleared or not, that we have to check it. Then while that our client is buying this property in the construction stage, and sometimes the developer is some other person, not the owner, then we have to check what kind of development agreements they are having. Then the tripartite agreement is the agreement that created by the Sri Lankan banks to to override this provisional condominium plan, because in the tripartite agreement you no need the provisional condominium plan. That three parties, that the bank, developer and the purchaser agreeing in the developer agreeing to the bank, saying that once we complete the building, we are not giving the deed to this unit unless we are informing and we are entering that. Then we will make sure that they will enter into a mortgage bond also at the same time, and the purchaser also saying that they agree into that while the construction is going on, we are going ahead with the tripartite agreement, and once the building is completed, I'll sign a mortgage bond, that kind of document. That also commonly in this concept. And the sale and purchase agreement, it's a very common document between the developer and purchaser. That also you have to check, is there in that recently that I got from that very famous developer, one clause stating that you at the end of the project, you have to do the deed of transfer through the notary of the developer. Actually, that those things that you can't accept, that you have to discuss with the developer whether these clauses are reasonable or not. And there's another clause recently I got that regarding the same thing what we discussed about the COC, that once you obtain the certificates of practical completion, the developer is handing over the unit. Like that, many clauses can come up, and that we have to concern about the clauses in the sale and purchase agreement. This escrow agreement, while Mr. Deseram and myself, that we were lengthily discussed on the escrow agreements that for introducing to the condominium industry, but some developers are presently doing now when the all funds taken from the customers go into this account. But that we all believe that, including myself and Mr. Deseram, this escrow concept must come to this thing. Mr. Deseram, can you elaborate a bit on this
Yeah,
matter?
so basically, escrow accounts are basically where the developer will contact a bank, and the bank, like when you do a house, now you are familiar when you take a loan for a house, the bank will monitor your house and release the money basically as you go on with the house. So this sort of escrow agreement is good because then the projects don't fail. Because what we find was in big projects, sometimes the money for one project is used by the developer for other things. Sometimes it's not put into your project, and sometimes the developer goes bunk. So then what happens is, if you had an escrow account, then you have an escrow account with the bank, and the money that the purchasers go into the bank on the escrow agreement, bank will monitor the progress of the building and release the funds, so that the funds don't go to any other project or any third party or so on and so forth. So we were pushing that this escrow account be a mandatory thing, like in some of the other countries, to safeguard the purchasers, because now you can see a lot of projects are struggling because they have used this money for other things. So these are the basic documents that a notary will be dealing with in a project. I always tell when we go for these lectures, look at the amount of work that is there for a notary in a project like this. So it is important that you know this area of the law, because you can really do well. If you just do one project, you know what it is and you can learn what it is. And the amount of work that our profession has in these buildings. The next one is the manner in which condominiums properties are transferred. I'll give it back to Mr. Jayasekara because he is good at notarial work.
Say that that we discussed the semi-condominium plan and the declaration, and the condominium plan and the declaration, that once if it's a partially completed, even that we can do a condominium plan and the registered at the condominium management authority. Thereafter will register in the land registry, as well as once you complete the building also, that you will do the condo plan and the deed and register. In the both occasions that it's a completed building, then you can issue deeds of transfer to prospective buyers, that then in the deed of transfer that that you will get the 100% ownership to your unit, and the partial ownership as per the share value what we discussed of the common elements. That is how it worked out in the, and then those are the basic documents. Yeah, and then the condominium properties are transferring, say that the legal ownership. So as we discussed earlier, that the provisional condominium plan, we can do only two things. The first one is that the owner, that the developer at that time, that enter into a sale agreement with the prospective buyer for the unit which will be built in future, that we are selling to you. That is the one thing. And the second thing is that based on this sales agreement, bank also can give a loan to that the developer that will get the money, that enter into a not the tripartite agreement like other cases, that the directly a mortgage bond. Only those two things you can do. But however, that once you completed the building and get all those approvals and prepare the condominium plan or semi-condominium plan, and register the plan along with the deed of declaration or deed of the semi-condominium declaration, then you are 100% free to transfer it, then in the retransfer it whatever you want, and along with whatever the accessory parcels also transfer into a new owner, and along with the whatever the percentage you own of the common elements. Say that this common element, that share percentage, that another thing you have to add, that one day if the building is destroyed, then say that you own the 0.05% of the common elements, that end of the day that this land belongs to the condominium property is always a common element. You own that 0.5% of the land, that ownership will lies with you. That is how this thing work out.
Yeah. So basically, as Mr. Jayasekara said, to put it in a nutshell, if the condominium plan is registered, no issue. It's a normal transfer like what we do for normal houses. If it's not registered, you will have an agreement to sell, and the developer, once the condominium plan is registered, will issue you a deed. These are the types of approvals. I think it's now 6:45. These are the general approvals that are required, basic approvals for a condominium project. We were, between the two of us, we wanted Mr. Jayasekara to describe this in short, but shall we skip it, Mr. Jayasekara, because it's 6:45?
It will take, we'll skip
it. Will take some time.
Yeah, some time.
Sorry about that. Things to do for a developer: you have to do a market survey, propose costing, your finances, right? So basically procedures, then the developer, what he has to look at, and things to do if you are a purchaser. These are important lists that we have managed to put together. Know your developer, look at the title, look at the rights have a look at the approvals, look at the mortgages, look at the sales agreement clauses, which Mr. Jashekar was saying. You'll have funny clauses that are put there that basically sign off your rights. Look at whether the condominium plan is there, your taxes, check any disputes in the building. If there are disputes, don't touch it. Quality of the building and home rules. Things to watch if you are a finance, if you are doing a bank, check the title to the land, new regulations sometimes affect the project. Make sure the developer is done under the approved plans, microeconomic factors, occupants. Now, if you're having a loan, make sure that the occupants of apartment don't occupy the apartment. Otherwise, if you have an issue in executing the mortgage, then there is an issue in getting them out. So things to watch out as a management corporation. Also, we have listed out a few. And dispute resolution, where you go. You first sort out your management issues in the management corporation. If you can't, you can go to the condominium management authority. You can go to the district court. You can go to the magistrate court, or you can go to the apex court. So these are the places you go for dispute resolutions. We are just moving on forward in a hurry because we are losing out on time, and we will be open for question and answer if required. The two of us are there.
I would like to give a reminder to our participants that if they have any questions, to post them in our Q&A box so we can refer them to our two panelists. While if any questions come in, sir, is there any final remarks that you would like to share with our viewers?
Okay, so just to recap, we just did a basic law as the Bar Association wanted us to do. This is not a topic, actually, you can finish in 1 hour. Anyway, I hope we did our best. Mr. Jasekar and we were talking about it in the afternoon, what shall we do? But educate, if you're doing anything in this area, please educate yourself, because if you do something wrong, it's very, very difficult to rectify. And you're talking of millions of rupees of your client. If you're representing a developer, or you're a purchaser, or even if you're doing a contract, so educate yourself on the law. Or if you're a banker, and if you find it difficult, I'm sure the two of us, we will be happy to help you all at any time. You can call us, there is no issue. And make sure that whatever you do is legal. Like, otherwise, you have situations like what Mr. Jayasekara said, where you can't rectify things that have happened, where in some places there have been deeds written on provisional condominium plans and so on and so forth.
Okay, we have one question. So I will post this question to both the panelists. So it says, so I need to know whether once we get the semi-condominium plan and semi-condominium declaration, can we execute the deed of transfer without getting the final COC or final condominium declaration? Please clarify. Thank you.
Yes, basically that semi-condominium plan approval and the registration giving only on the partial COC. In this partial COC, that the relevant municipal council or the UDA, they will check that the unit and the relevant common elements attached to that unit is completed. Then only the semi-condominium partial COC given. Based on the partial COC, only Condominium Management Authority giving the certificate of common element for the partially completed building. Then only with both certificates, that the partial COC and the semi-condominium certificate from the Condominium Management Authority, we have to go to the land registry and register. Once you register that thing, that you can give deeds, no issue at all. It's a commonly it is accepted. And that when once you completed the building, there might be a final condominium deed and the plan, but there is no effect on the deeds already transferred by the semi-condominium plan and the deed.
Yeah, and I
Thank
think, Mr. Jasikara, it's only applicable to those units that have been obtained like semi-condominium status.
Yes.
Yeah, you have to be very careful there because some of the developers use that and try to sell other things that are not part of the approved units.
Yeah, that when that if you are a notary, that when you are doing a semi-condominium declaration, that those units you have to clearly mention that these units are not completed. That will say that out of 100 units, you complete 80 units. Then the best thing is not even insert the schedules of the uncompleted unit in your semi-condominium declaration. Then no one can't do any uh, bad things to the clients.
Thank you, sir. So actually, with the time allocated for the session is coming to an end, I would like to take this opportunity to conclude the session formally. So I thank, and this brings us to the end of the 11th webinar on the series of Basics of Law titled Condominium Law. I thank our esteemed panelists, Mr. Samindra Jayasekar, attorney at law, and Mr. Senaka Diseram, attorney at law, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSF Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. I also extend my thanks to all the participants who have joined in for this session today. And I thank you once again, and I hope you all have a very good night. Thank you.
Thank you. Good night.
Thank you very much.